was in the public prosecution of his states before he became a judge. So he comes with a very rich history, and I hope that we would have the benefit of having him on today before the end of this session. Having said this, today's topic, which my Lord would eventually deal with, need to understand that he's prepared adequately for this, deals with appeals against no case submission. The first order of business here is, when should it be made? I'm going to attempt to just run through the issues surrounding appeals against no case submission using some bullet topics, which I would always introduce before talking about them, so that we can all follow the trend of this discourse. Now, there's been a myriad of opinion as to whether a no case submission, a decision on overruling a no case submission, is an interlocutory decision or it is a final decision, because this argument is very important in the sense that it determines whether it is a decision that one has to appeal within 14 days, or it's a decision that one has the benefit of appealing within 90 days, in line with the relevant provisions of the Court of Appeal Act and the Constitution. Of course, that is one leg of the argument. The second leg of the argument is whether a no case submission is an appeal that requires the leave of court or can be done without leave of court. There are a plethora of decisions by both the Supreme Court and the Court of Appeal on this issue, and this is the interesting area that I would like us to pay close attention to. Now, with regards to the first aspect of the discourse, which is whether when the no case submission, when the appeal should be made, whether within 14 days after the decision or within 90 days. Honestly speaking, I always, in my humble view, like to err on the side of caution. Because what is an interlocutory decision? An interlocutory decision is a decision that does not terminate a trial, while a final decision is one that terminates a trial. That's one way of looking at it. It could also be interpreted to be that with respect to the issue itself, the court has reached a final decision, meaning that there's no opportunity to raise the issue again, which is like you can't make two no case submissions in a trial. So some people will say, oh, it's a final decision. For me, in order to avoid all those interpretations that could create problem for you at the Court of Appeal, the best thing is, as soon as a no case submission is refused, treat it as an interlocutory decision and immediately arrange to have an appeal filed. You can file if you want to file it, the question will not be, do you file with leave or do you file without leave? Of course, if the issue is on points of law alone, you don't need the leave of court. But if it's going to be mixed law and facts or facts alone, you need leave of court. That brings another problem on its own. And in this respect, I always tell people, err on the side of caution once again. Seek the leave of court, either of the High Court or the Court of Appeal. Most times what I do is I file. If I know that time is against me, I file, and then I go to the Court of Appeal and I seek the leave of the Court of Appeal. Once all the records have been transmitted, so that my appeal will be properly before the court and I can file my brief and all other processes that I need to file. This way, I avoid the danger of being told that I have an incompetent appeal, because you can seek the leave either at the lower court, that's the High Court, or at the Court of Appeal. I've done this before. So it's by way of procedure and practice, it's not something that is unusual for lawyers to do when you know that time is against you. The most important thing is that at the Court of Appeal, if you do not seek leave at the High Court, at the Court of Appeal, it's important that you apply to the court for leave, because most of the decisions that border on whether leave is required when you are filing an appeal against a no case submission is such that tilts towards the fact that a consideration of a no case submission by either by the lower court, as it were, and any decision against it will require you to touch on facts. Because essentially what you are saying, in view of the narrow grounds under which you can file a notice of appeal on the refusal of a no-case submission, is that one, the prima facie case was not established by the prosecution. That's the first ground. And we all know what the prima facie case simply entails in that context. It simply means that you are saying that the evidence adduced by the prosecution has not been able to establish the essential ingredients or elements of the offenses for which the defendant, now appellant, has been charged at the lower court. The argument, or rather the position of the appellate court, has always been that if you want a full determination of whether the High Court wrongly refused the no-case submission, it is impossible to do so without looking at the facts that were adduced at the trial. In other words, let me give an example. You have a situation where someone is accused of, say, fraud or obtaining money by false pretense, and evidence has been adduced by the prosecution. They've closed their case, and you make a no-case submission saying that, oh, the elements of the offense of obtaining by false pretense, there must be what do you call it now? There must be a pretense that was emanated from the defendant to the victim. The victim must have believed it and relied upon it to his detriment, and the person who offered that pretense knew it to be false at the time he offered it. Now, all these things are not things that you can construe as having been adduced, the evidence adduced by the prosecutor as having established it, without referring to perhaps maybe evidence of the prosecution witnesses, which you believe did not establish the elements of the offense, on one hand. Once you are going towards that direction, the Court of Appeal has always been of the view that that means that one must look at the facts of the case. So it's not a case of mixed law and fact, because for you to determine whether a point of law, a ground of appeal is only, it is the particulars that the court will look at to say, okay, if you say that this is your ground of appeal is XYZ, what are the particulars that you are relying on in support of that ground of appeal? Those particulars would necessarily dwell on facts. So it simply means that in most instances, if you are not, it's not a cut and dried situation where you say, okay, this is the position of the law, the court did not apply this law, it becomes difficult for you to say that it is not a question of mixed law and facts. So the safest route is for you to seek leave of court to appeal, and then of course your appeal which you have filed will now be probably before the court in that instance. So we are dealing with two situations here. First, when do you appeal? Is it 14 days after the no-case submission or 90 days? While the school of thoughts are so in support of these two positions, personally, like I said before, I always like to answer the question by filing within the 14 days. Now, if the 14 days, you believe that it may be difficult for you to obtain leave at the High Court before you do so, file your appeal, compile your records, go to the Court of Appeal and seek leave of the court and explain the circumstances under which you were unable to seek leave at the lower court, so that the Court of Appeal can grant you that leave to appeal on mixed law and facts and also come before it properly. That way, you are certain that your appeal will not be affected by any application that it's incompetent. Now, I would like to go back again to the issue of whether with leave or without leave. It is important also for us to always have at the back of our mind that the right to appeal is a constitutional right, but that right is also clearly defined as to when it is exercisable and when with leave or when it's not exercisable with leave. The provisions of the Constitution, I think 241 and 242 are clear in that respect. So it is important for us to study our case, understand whether we need leave of the court to appeal or we don't need leave of the court to appeal. And like I said, again, I repeat, it is the circumstances or the grounds of appeal that really determines whether it is a ground of law, in which case you need no leave to appeal, or it is a ground of mixed law and fact, in which case, or facts alone, in which case you need the leave of court before you appeal. And I have mentioned that because of the nature of the narrow constriction that we are placed when we are dealing with a no-case submission that restricts you to asking the court to dismiss the prosecution's case on the ground that they've not established a prima facie case, or that in the course of the trial, you have discredited the testimonies of the prosecution witnesses such that no reasonable court, even if they believe those testimonies, can rely on it to convict. Now, that second ground is the one that even makes it of utmost necessity for you to seek leave, because if you are saying that you discredited the testimony of a prosecution witness, essentially you are telling the court that with respect to the factual situations of what took place at the trial, a witness who was supposed to establish a particular elements of the offense was discredited in the course of cross-examination. And those are factual situations, because you must argue about the kind of question you ask and the answers that were elicited, and link it properly to the allegations before the court to show that there was no way, there's no way the lower court ought to have dismissed the no-case submission in view of the nature of responses gotten from prosecution witness. So automatically, you are asking the Court of Appeal to look into the facts that took place at the trial. That means that your ground of appeal cannot necessarily in that circumstance be of law. Perhaps you could say, oh, the application of the law to the situation is what you are quarreling with. That's okay. But the problem will be this. Before you get to the point where you apply the law, you must state the facts of a case, so that the particular law that is applicable to those facts would now be deduced based on the facts you have stated. So it becomes a case of it's difficult to divorce one from the other. Now, to avoid any situation that will lead to your appeal being deemed to be incompetent, it is essential and necessary for you to now err on the side of caution, to just seek for the leave of court to appeal, for your grants of appeal, those of appeal to be competent, and then proceed with filing your brief so that you can be properly before the court after the Court of Appeal would have granted you the necessary leave to file the notice of appeal, the grounds of notice of appeal that are mixed law and facts. That is where you fail to obtain leave at the High Court before you file notice of appeal. Now, what is the effect if you fail to file without leave when leave is required? Automatically, once the prosecution raises that issue at the Court of Appeal, maybe you have filed your brief, you have you have compiled your records and transmitted it and filed your brief, the matter is almost ready for hearing, and then in the prosecution raises a preliminary issue of law in by way of motion and argues it inside the brief, saying that your appeal is incompetent because it contains grounds of mixed law and fact, and you did not obtain the leave of the court to file the appeal, for both the Court of Appeal or that of the High Court. Any argument in that response, in that respect, that you do not respond to appropriately, would lead to the Court of Appeal saying that your appeal is incompetent. And of course, the decision that will go follow it to be dismissed. So in one instance where we had that challenge, what we did was this. When we filed without seeking leave, and the prosecution raised this particular issue and argued it in their brief, we saw the danger, though we're convinced that our ground of appeal was of law, but we thought twice about that and said, look, with the decisions of the appellate courts that seem to suggest that it is difficult to say that a ground of appeal involving no-case submission is a purely law. It will be our best interest to exercise, urge the court to exercise its discretion to grant us leave by filing the necessary application, so that application will be heard before we go into arguing the appeal. And that's exactly what we did. We filed an application seeking the leave of court to regularize our appeal, and the court heard it and granted it. We all know the position of the law that where there is an application to regularize a position that would necessarily lead to a dismissal of a case, the court would necessarily give that application preference to hearing the main application that would dismiss the appeal. So that was what saved us in that particular instance. The prosecution then decided to abandon that aspect of his objection that it had argued inside his brief and went on to just argue his brief on his own without the preliminary issue of law that it is raised. Now on the screen, you will see that this is the slides of my Lord Justice Shuaibu that was shared today during his presentation. It talks about the rights, every person who is charged with a criminal offense shall be presumed to be innocent is proven guilty. Of course, this is the section of the Constitution that guarantees that a person should be given a fair trial because he is innocent until proven guilty. And we all know that the burden of proof is on the prosecution, which is beyond reasonable doubt. So until that is done, the constitutional right of the person to be presumed innocent is guaranteed. This is not entirely the topic of today. I think my Lord brought this as an introduction towards the issue of no case submission. If there's another slide to be shared, we can just be going through it so that we can take a look at it. But before the second slide is shared, I would like to now draw attention to what I was talking about, which was what the effect was of failure to file without leave when leave is required. Like I said before, it simply means that your appeal becomes incompetent. And a decision to dismiss the appeal is the only outcome of such an appeal. Now, the available remedy when filed without leave of the trial court. Obviously, like I said before, if because of the circumstance that you are faced with at the High Court, having the local submission having been refused, and then of course the matter adjourned for you to open the defendant to open his defense. If it is now going to be very impossible because of the time factor, if one has to construe that decision to be an interlocutory decision, which I always advise it should be so construed, it simply means that 2 weeks may not be enough for you to seek the leave of the lower court to apply for leave to file a notice of appeal against this decision, as well as compile records and do all that you need to do to make the appeal be properly before the Court of Appeal. So I would rather that you spend energy preparing the notice of appeal, file it, compile records, transmit it, and then go to the Court of Appeal and seek the leave of the Court of Appeal to regularize your notice of appeal and all other processes that will make your appeal be properly before the Court of Appeal. So the available remedy in this instance would be that if you're unable to seek leave at the High Court, you can do so at the Court of Appeal. But what you must not do is to ignore seeking that leave or looking at your grounds of appeal and then thinking that it's all purely grounds of law, so you don't need the leave of court. If you do not seek the leave and you make an argument that your grounds of appeal are all based on legal grounds, and the Court of Appeal rules against you that no, your grounds may have been couched as legal grounds, but that is not your grounds per se that determines whether is the grounds, the way you couch it's not the way you couch your grounds of appeal that determines whether it's law or mixed law and fact. It is the particulars afterwards that is construed by an appellate court or a court to determine whether it is a ground of mixed law and fact. And once the court determines that it's grounds of mixed law and fact, and you have argued already that it's a legal ground, meaning that you never applied for leave of court to file that notice of appeal or regularize your appeal, automatically you have ruined the chances of your appeal being heard on its merit because the court will dismiss it. It's like putting something on nothing. So I always suggest that it will cause no harm for you to seek that leave so that you can be comfortable enough in the way you argue your appeal without wondering as to whether there's going to be an objection raised to his competence or otherwise. Now, looking at the screen, my Lord is taking us through the no case submission being a procedure that has always been in our criminal under our criminal procedure codes, and of course in the recently enacted ACJA in 2015, several provisions that provides for how empowers the defendant to make a no case submission 302 and 303 of the ACJA. in all other administration of criminal justice law across the country, the right to make a no case submission is also embedded in each of those sections, which is simply a procedure resorted to by the defendants to say that, having listened to the prosecution's case against him or her, having heard the bulk of the evidence tendered, and the prosecutor having closed his case, in his own view, they have not made out a case against him sufficient to warrant the court calling on him or her to enter his defense. Now, there can only be two ways, like I said before, when a no case submission can be upheld by a court. It's a very narrow area that leaves the court with no room to maneuver. The first is that, like I said before, you are saying that a prima facie case has not been established by the prosecution against the defendant. And prima facie case has been interpreted in a plethora of cases to simply mean that the essential ingredients of each of the offenses or some of the offenses for which the defendant has been charged were not established from the evidence adduced. Now, there's the particular case, I think it should be the Adolphus Wawara case. I can't remember the citation now. Had got up to, I think, the Supreme Court or Court of Appeal, if I remember correctly, where it is even possible to say that the prosecution was able to establish some kind of connection between the facts that led to the institution of the charges and the defendant. But in that case, what the defendant is saying is that even if you can establish that I am involved in this particular transaction by virtue of maybe my office, or my circumstance, it is not enough to say that a case has been made out against me. What is essential is to link my involvement, either by circumstantially or otherwise, to the case itself. That's the core of the allegation. Now, if I work in a bank and I have to sign certain documents, I'm just making an example now. I have to sign certain documents which ended up being documents that were used in the commission of a crime at another end, unrelated to the point at which I probably signed those documents. Obviously, in the course of giving evidence or adducing evidence, the prosecution would necessarily mention how I got involved at that point. But a deep dive into the establishment of the allegations by the prosecution through its witness will show that, aside maybe performing those duties that anybody could have performed, it's an inescapable duty. There was no way anybody could have said that the evidence was laid above and beyond that point to the point where the crime was committed with those documents. Now, that kind of situation also can be a situation where someone will make a no case submission. And in some cases, it succeeds. It succeeds because at that point, what the court is looking at is the allegation has a specific charge against the defendant. The actions that the defendant was alleged to have done are contained in the particulars of each of those offenses. Was there any evidence led by the prosecution to establish those allegations in accordance with the charge, in accordance with what it would take to say that a prima facie case has been established with respect to each of those allegations? Once it is clear that the prosecution witnesses were unable to do this, it becomes a veritable ground for the Court of Appeal or the High Court itself to say, look, we do not agree that you are able to make out a case against this party, even if you're able to establish that his name is right in some of the documents. It is not his name being on the document that matters. It's the fact that there is evidence linking him to the actual commission, or reasonably linking him to the fact that he can be said to have an explanation can be said to be demanded of him based on certain evidence that the prosecutor adduced to his witnesses. So these are the situations that one looks at when making a no case submission with respect to prima facie case. So on the other hand, where you are saying, oh, the witness of the prosecution, they said X, Y, Z, or they said this much, and during cross-examination, they were discredited or the entire testimony was overturned. Now, that is another area. So there are two separate areas. That is another area. because of these two areas, which is one on the issue of discrediting the witness and the other one, failure to establish a prima facie case, your notice of appeal cannot go outside these two. We have had cases where you, and I will be really, really pleased if my Lord would join us so that you can share his experience with us in this respect. There are instances where lawyers in filing a no case submission appeal go to town with all kinds of grounds of appeal that border on that looks as if the matter has been decided on its merits. No, grounds of appeal on a no case submission should not be too many, because you are not asking the courts, either the High Court or the Court of Appeal, to at that stage start looking at the merits of the case itself, because they've only had one side of the case. So evaluation cannot even come into its consideration. The difference between evaluation and consideration, which should guide us in preparing our notice of appeal in the course of a no case submission, is anchored on the fact that when a court is called upon to consider a no case submission, especially at the appellate level, which is what is being dealt with at this stage, it is only invited to look at the evidence adduced by the prosecution at the trial court and see whether there is anything in it that requires the defendant to go and open his defense or respond to those allegations. Now, it's not a ground, it's not an avenue, or it's not the right time for either the Court of Appeal or the High Court to be looking at whether a witness is to be believed or not to be believed, or evaluating, which means looking at two pieces of evidence. There are no two pieces of evidence. There's only one, which is from the prosecution. So it is whether it falls short or measures up to. That is the only consideration given at that stage. So once it measures up to, in the opinion of the judex, that look, the prosecution witness have said enough to require you to come and give your own side of the story, that suffices. That is why there's always a warning that the High Court judge should not go beyond just saying that, in their opinion, the case has been made out sufficient to warrant the the defendant to enter his defense without more. It should not be lengthy. It should not be delving into the substance of the matter, because the danger is once you start evaluating and that state of considering, you have started looking at the piece of evidence and ascribing preventive value to it at the stage where you are yet to hear that of the defendant. So the grounds of appeal must necessarily be restricted to grounds that are touching on the inability. That's when you appeal against a no case submission that was refused. Your grounds of appeal should be directed at the core of the decision of the lower court, particularly with respect to either the inability to look at obvious failure to establish a prima facie case by the prosecution, or the very, very serious discrediting of the prosecution witnesses' testimonies that leaves nobody in doubt that really there was no reason to call on you to come and give your evidence. Of course, as we all know, Supreme Court has stated, I think in Subaru State, that calling the defendant to enter his defense at the stage where a no case submission ought not to have been refused is amounting to breaching the constitutional presumption of innocence, which is what we first saw in the slides that my Lord displayed here. So, for me, the most important thing is knowing how to draft the ground of appeal emanating from a no case submission. Because if you draft it in such a way that it goes above and beyond the restrictive and narrow areas that you should do, it will fail at the Court of Appeal, because you are already asking the Court of Appeal to do what the trial court ought to do at the end of the trial. So an example would be that you put it that the learned trial judge erred in law in his decision that a prima facie case was made out against the defendant. Now, when you leave it at that, the particulars would necessarily follow that the allegation against this was this. None of the prosecution witnesses adduced any evidence that didn't evidence in support of any of the elements of this particular offense. This particular witness, who was probably the star witness, stated so. These are some of the things. You narrow it down so that when the Court of Appeal is looking at it, they understand that you are saying that for a case of stealing, for instance, the item stolen, if it's money, that money was stolen by a defendant, and the prosecutor has closed his case, and you've made a no case submission, it was refused, and you go to the Court of Appeal and say, look, no prima facie case of stealing was made out against you, and then you probably say, look, let me give an example of a case that we're doing, though it's still on now, so I'll be very careful about making reference to it, but I'll just give us an idea for us to understand what I'm trying to say here. A particular defendant is accused of stealing. Evidence is being led through the prosecution to establish that the money he was alleged to have stolen is a salary, which was approved for him to take. He was paid those salaries. There are documents showing that these monies were his salaries. And then, of course, a no case submission is made in that instance, for instance, and the High Court says, no, there's document to show that you took this money. We are come and enter your defense. That kind of decision, when you want to appeal against it, you must, of course, go towards establishing that the essential elements of the offense of stealing is that there's a thing was stolen, it's capable of being stolen, the ownership of what was stolen, and of course, the permanent deprivation. Now, when you talk about the ownership, which is at the core of the allegation of stealing, in that kind of scenario that I just painted, the ownership through the evidence adduced by the prosecution witnesses, both documentary and oral, shows that the man was entitled to a salary. And it was approved that he should be paid the salaries. It is the same money that they are turning around to say that he stole, maybe because of one or two victimization of the man or whatever. That kind of ground, you need to narrow it down so that the Court of Appeal can go straight to the nature of the matter and say, look, yes, if the allegation is stealing and this is what was stolen, who owns the money? That immediately makes it clear. Who owns the money? The issue of who owns the money does not require the evidence of the defendant for it to be established that he owns the money. Because at the point where you are able to establish, we've had other, if we all can recall the previous lectures on the issue of how to present one's case through the evidence, through the prosecution witnesses as a defendant. We have all heard about how you use the defendant witnesses to establish the innocence of the defendant. So in a situation where the salary slip or pay slip and the man is tendered in evidence through the prosecution witnesses to establish that the same money that was paid to him as salary is the money that is now being alleged to have stolen. Obviously, it is now becoming clear, even from the case adduced, presented by the prosecution, that a consideration of the entirety of that evidence of prosecution witnesses by either the High Court or the Court of Appeal would not bring any other conclusion other than the fact that the same money that the man is alleged to have stolen is the one that is contained in his payslip. Under that kind of clear-cut circumstance, it becomes easy for the Court of Appeal to take a decision that strictly no prima facie case of stealing was made out sufficient to have warranted the lower court to call on the defendant to enter his defense in the circumstance. So you see that by trying to narrow the grounds of appeal, the particulars, and of course, the arguments that will support them when you formulate an issue for determination in your appellant brief, it is easier for the Court of Appeal to go straight, delve into the matter, and quickly take a decision on whether it was wrongly refused or not. Same thing can also be said about the issue of the second ground, which is discrediting the witnesses. I mean, a situation where you ask a witness for the prosecution, in the kind of example I'm giving now, that the man was alleged to have stolen, say, ₦1 million, and the ₦1 million is the same as that contained in his payslip, and he said yes. That payslip, is it what is given to every worker when you pay them salary? Yes. What is the process of paying a worker salary? He highlights those processes, which includes processes that involve approvals of certain levels of approvals up to the point where payment is made. And it's established through the prosecution witnesses that those approval levels were all met with. It becomes a bit difficult in that circumstance for anybody to say that the prosecution witness was not discredited, because if the same money that is alleged to have been stolen, is the same money that has not been legitimately established through the cross-examination of the prosecuting witness as monies that was paid to him as a salary, then obviously that money, the ownership of that money is no longer in doubt as belonging to the defendant through the discrediting of the evidence of the prosecution witness who had probably earlier on adduced evidence or testified to the fact that, oh, this money was stolen from our company by the defendant. So in that kind of circumstance, you're also able to narrow the issue, narrow the arguments, and bring the Court of Appeal immediately towards the reasoning you are quarreling with the decision of the lower court. But what we cannot do is now trying to use the medium of the no-case submission appeal to go into the substantive matter as if the entire evidence has been heard on both sides. In that circumstance, it's very clear that the Court of Appeal refused the appeal and dismiss it, because the Court of Appeal cannot be determining or evaluating evidence at that stage when only one side of the evidence has been heard. The Court of Appeal, I must also state here that the Court of Appeal has the power to evaluate evidence. I think that Section 15 or so of the Court of Appeal Act allows it to do so. Just if it is evidence that it involves documentation that is clear, that doesn't require it to hear evidence for it to be able to evaluate, it will be in the same position as the High Court to do the same job of evaluation of evidence. So, but that can only come at the end of the trial, when the two parties have given the evidence and the decision has been made. It's a final decision, and of course, you are unhappy with it and you have decided to appeal against it. At that stage, the Court of Appeal can decide to look at whether your ground of appeal, which we border now on the court did not properly evaluate the evidence, can now be done by the Court of Appeal exercising its powers under Section 15 of the Court of Appeal Act. So we must be careful in the way we draft that's the point of all I'm trying to say here, that we must be careful about the way we draft the ground of appeal in a no-case submission, because of the narrow and restrictive nature of the entirety of the situation of a no-case, which limits us as counsel to areas where we can call on the courts at the High Court, that is, to discharge the defendants, the case not been made out against him, or when we can approach the Court of Appeal to say that the High Court did not do the right thing by refusing the no-case submission, meaning that the nature of the appeal and the nature of argument will not change from the way we argued it at the High Court to complain about the way the High Court itself, that the judge of the High Court, construed our argument. So that's a very important distinction, because if you argue as if you are making the no-case submission afresh before the Court of Appeal, without linking it to the decision of the court itself, you are simply changing venue but arguing the same thing. No, that's not the way to do it. You will need to point out the fault that the court has committed, or that whatever, if we should use that word, the area of how the court did not do what it ought to do, and then support it with what took place at the lower court, so that the Court of Appeal can be in a position to either agree with you or disagree with you by saying, look, I don't agree that the court did the wrong thing. Oh, I agree it did the wrong thing. It ought to have taken this particular decision based on what is there. So it is essentially a quarrel with what the lower court did, rather than what the prosecution's failure to establish its case, which is what you do at the High Court when you are presenting your no-case submission. This distinction is important in bringing forth, and in a clear and precise manner, your argument at the Court of Appeal if you want your no-case submission to succeed. If you do not present this distinction properly, it becomes very, very difficult for the Court of Appeal to agree with you, because once you start dragging your arguments and to the point where you are asking the Court of Appeal, look at what this witness said, they ought to have said so and so, they didn't say that one, they not said this one, you are not the one who is trying to urge the court to go beyond consideration to evaluation of the evidence. At this stage, I would like to look at more of the slides from my lord. Maybe I can touch one or two areas that here I have not spoken. I know that when I'm looking at these old slides that I've just been talking about most of the issues raised in the slides. Like here, they said the piece of evidence did not link. Okay, I've spoken about this issue of linkage, which is what I said before, that the link that is important here is the link to the actual commission of the offense or reasonable suspicion of having committed that offense at the point where it is essential to call on him to come and give enter his defense. The defendant who can raise no case submission, the defendant comes to raise and resolve. Under ACJA, my lord has clearly stated that the defendant can raise the no case submission, which is what I've said before. The court may on its own, having heard the evidence, raise it and resolve it. And the provision that allows the court to do and the defendant to do that are clearly stated. Next slide, please. Next slide. Okay, this particular slide is, of course, about what I have been saying since about appeal against the no case submission. The decisions are clear. This Isegoin and FRN Isegoin is partly for me. It was a matter that I was involved in, so I know this matter very well. We did the High Court trial in that matter, and we were very confident that no case was made out. So we made a no case submission before the Honorable Justice Chuku of blessed memory, and he refused our no case submission in this FRN Esegoi. He refused it, and we filed an appeal. And one of the grounds of appeal that we filed was that there was no case made out against the defendant in that matter, because it was a case of money laundering against the defendant. And it was a very funny case in the sense that it was alleged that the defendant had laundered, I think, about 15 billion or thereabouts. Yes, 15 billion naira, whilst he was the MD of a particular transnational company. And we went into the records of the company, which we presented in the trial, to show that during the tenure of the defendant as the MD of the company, the monies available to him to work with was not more than 2.5 billion. So the question was, we put the question straight, that position was confirmed by the company officials who came to testify. So we put a question straight towards the what's his name now, the IPO, to ask him in a very simple way how much was available to the company for at the time the man was MD, because of course he cannot launder more than what was made available to him to work with. He agreed. And we showed him the company's own record. We showed that the man had no more than 2.5 billion all through the period he was with the company. So how could he have laundered 15 billion? My lord, in his wisdom, overruled us and went to the Court of Appeal. And the Court of Appeal, if you look, you guys can look up on the case, the Court of Appeal agreed with us that no case was made out, that even the use of the word may have been made out by my lord in his ruling refusing no case solution was wrong, because it's either the court is agreeing that a case was made out or it was not made out. Not to say that it may have been made out, because once you use the word may have been made out, it simply means that the court is still unsure of whether a no case submission, a case was made out against the defendant. And of course, we all know that when there's a doubt, it should be resolved in favor of the defendant. On time to appeal, this is interesting. Let's see if there's any other slide so that we can look at whether my lord was specific on the issue of time to appeal. Next slide, please. Well, there's no, maybe we'll wait till my lord comes so that if my lord has a contrary position to what I have said. Like I said, the school of thought are open on time to appeal between 14 or 90 days. Some people feel that no case is a final decision, so it should enjoy the 90 days window. Some people are of the view that no, it's an interlocutory decision in the course of a trial and ought to be 14 days. Whatever the case may be, I always on the side of caution. So I hope that when my lord makes it here, we'll probably be able to ask him about this particular aspect to know what the appellate courts have been deciding on this Hello, can you hear me now?
Yeah, Docs, we can hear you now. Thanks.
I didn't know that I had lost network when, so I don't know where I stopped. Really, I was looking at the slides by my last slides where we're talking about nature of grounds of appeal. Are we still there?
Yes, we're still there.
Okay. So I have spoken extensively on the nature of the ground of appeal. That was the last part I was discussing now before the slides came up, which is the nature of the grounds of appeal in naked submission are very restrictive. You cannot be appealing on naked submission and be talking about issues of evaluation or issues that border on the substantive merit of the prosecution's case to the extent as if all the evidence are already in and the court of appeal can take a look at it and reach a decision. You must restrict yourself to the narrow grounds that are afforded a defendant when he wants to make a no-case submission. And I also drew our attention to how it should be couched on one ground, and on the second ground as to the nature of how we should pursue it at the Court of Appeal when we are making our argument. Our argument at the High Court is we are attacking the prosecution's case. We are essentially telling the High Court that look at the prosecution's case. It is not be able to measure up to establishing a prima facie case, or we discredited the prosecution's witnesses such that you cannot even rely on them, even if you believe them. The court will have to look at it and decide, I agree with you or not, or disagree with you. But at the Court of Appeal, you are quarreling, your quarrel or your grouse is with the way the High Court reached a decision on your argument. So there must be a linkage between the decision of the High Court to the events that took place at the High Court with respect to what you argued about, such that it is that decision of the High Court that you are attacking. And in attacking it, in arguing it, you can bring in why you believe that the judge of the High Court was wrong in his construction of the arguments you made. So that what the Court of Appeal is doing essentially is trying to now put itself in the place of the High Court to determine that if it was those arguments were made to it as the court that was reviewing your argument, would it have reached the same decision? It is the danger in trying to behave as if you are re-arguing your no-case submission is that you are attacking the prosecution case, not the decision of the court. An appellate court is essentially a court being called upon to look at what the lower court has done, either from the Supreme Court looking at the Court of Appeal decision or the Court of Appeal looking at the High Court decision. So your grounds of appeal must be narrowed and directed at the decision of the court, the ratio for the court's decision, not to be argued at large as if you have this is another venue for you to now begin to argue your no-case submission. No, you bring in your no-case submission argument to establish why you think, as a matter of law or procedure, the lower court judge erred in the way he applied the law to the arguments you made. So I think that's what I was trying to say concerning the way the nature of grounds. They are very narrow, very narrow. It's either you are saying that the judge at the High Court failed to construe your arguments with respect to properly construe your argument related to how the prosecutor failed to establish a prima facie case, or that in view of the discrediting of the cases of the prosecution witnesses, the testimony of the prosecution witnesses, it was not the court erred in law in urging you to come and enter your defense, so that you now follow that line of argument. How did the court construe that? If the court failed to make a comment on it, that failure to make a comment on that aspect of your argument is also part of your decision, your quarrel against the court decision, so that you encapsulate your argument in such a way that the Court of Appeal is able to see through the entirety of what your grounds is. It doesn't have to be a very lengthy submission. It just has to be a very effective pinpoint argument as to the area you are quarreling with. It is a lot better when the Court of Appeal can see your complaint early enough, understand it, than when you start going around trying to re-argue your no-case submission as if the Court of Appeal is the court of first instance. I've spoken about remedy for seeking leave. Do we have any other slide that we can take a look at? I think I've spoken about this. Any other slide? Okay. Okay. I'll just read out what my Lord is saying. When no case increasing income in norm virtually all criminal before the position policy in place. The prosecution for the against information. I think this particular, I must commend my Lord for this conclusive position, because this has always been our position. Although they accuse us defending the defense lawyers as making arguments that only in support of our position, which is wanting always to quarrel with the way either the prosecution is prosecuting the case or the way the judges of the High Court are construing no case submission. You see, all of us who are always very active in the criminal litigation world would agree with me that it does appear as if no case submissions these days, out of every 10, maybe 1 or 2 will succeed. And this is because, obviously, we cannot divorce what is happening in the society and the need for judicial activism from what we are seeing, the way decisions are against no case submission. When you read cases that are in the 60s, 70s, 80s, and even the 90s, you see that the judges of those days, they looked at no case submission as a veritable tool to bring in an end to a prosecution that ought not to be in the first place. They see through the gamut of the prosecution's case immediately and say, look, this man ought not to have been brought before this court, or this man ought not to have been charged in the first place. But these days, without meaning to accuse anybody, it appears that the judges are always looking for ways and means of drawing a nexus between what the prosecution evidence is saying and the fact that the defendant must come and give evidence. At the end of the day, most times they free the defendants, yes. Sometimes it is what happens when the defendant comes into the witness box that leads to a conviction, which is not supposed to be so. And I think this is what my Lord is saying here, that most of it is the way the prosecution is policy of prosecuting cases that is leading to almost every trial becoming a no case submission made in almost every trial. And this is so because a defendant wants will not want to place all his eggs in one basket. Once he believes that the court did not treat him fairly, or it was unfair in the way it determined his no case submission, the next thing will be to file an appeal while he continues with the trial, so that perhaps before the trial ends, the appeal from no case submission at the Court of Appeal may succeed and to bring an end to his prosecution, or at least he will have another window to be pursuing an alternative decision pending when a judgment is given, that and have a second bite at the cherry, so to speak. This is now what it is looking like, which is not supposed to be so. Prosecution is a very, very powerful tool, which is given to a prosecutor and the state and the society to pursue and punish those, bring to account those who have committed a crime, so that we can maintain order in our society. But when it is being done in a manner that makes it look as if no serious thought process is put into whether a matter should be taken to court or a charge should be brought against a defendant with the power of the state against him is left with no option but to always seek ways and means of approaching the courts to determine at every level whether he will get any justice. And of course, this has led to a lot of delays in our criminal litigation process, where you see one trial going on for so many years. Thank God for the innovation that came up now, saying that an application to an appeal on a no case submission or interlocutory appeal cannot stop the Sultanic trial from going on. We would have been suffering the situation we are suffering right now if we had to stop the main trial, get the no case submission up to the Supreme Court, and then come back to resume trial. 20 years, you are still trying one case. So I hope that with these little things I'm able to say, I've been able to step in adequately for my Lord till such a time that we can have his presence here. I see that Professor Nasiru, my fellow course coordinator, is here now. Maybe I will hand over to him or to our chairman, Mr. Tobena Rojikwe. So that is all. Thank you very much.
Prof.
We can't hear me, Bill.
Yes, Doc. Yes, how are you?
I'm fine, thank you.
Can you hear me? Yes.
Yes.
I'm on my way, I'm on journey, but I still followed you. It's really commendable you, at least before my Lord joins. But I understand my Lord was still in court at maybe 30 minutes ago. But I believe you have started the introduction to the topic. Let me just use this opportunity to just tip in something in respect of issue of appeal against local information before my Lord comes also, because my Lord is the master of all, so we'll just put our own. You know, I have seen 2 cases cited by my Lord. I'm particularly of interest that Uncover versus Federal Republic of Nigeria. It's a case that I have read very well. It's a case that I understand. And I think in all the army of cases, in all army of cases, I think the only case I have seen very clear on the issue of whether when you're appealing against making submission that you need to take leave or not. I think this is one of the few cases that is very clear where Supreme Court said that where you are going to appeal on a case making submission, that if you have not restricted yourself on issue of law alone, like you have made mention one of those points. For example, failure of my law to comment on issue raised, that is law, surely. So if those are kind of grounds you have, then they are purely law. But when it comes to issue of what you want the court, appellate court to resolve that the lower court had wrongly overruled you in view of the fact that the fact and the law does not or do not support the case to show that there's a prima facie case against the defendant. In that respect, it was very clear, said in that respect, it is a mixed factor law. So if you appeal without taking leave of the court, the appeal is incompetent. Now, you see, coming back to the issue whether it is an appeal, a final judgment or an interlocutory, Supreme Court says, where the no case submission is upheld, then that is a final judgment. So it means you have 90 days if you are appealing from High Court to Court of Appeal. But if you have, the issue of appeal from Supreme Court to Court of Appeal, which the most people are missing the point, due to Supreme Court rule. Instead of that, 90 days is 30 days, right? So these are one of the areas that I think we should be very, very careful as people in criminal litigation. That no case submission as it is, if the counsel is clever, where you are entertaining doubts as to whether any case has been made against your client, or you want to have an idea of how to narrow down areas of contention. Most at times in criminal litigation, you resort to no case submission. Then at that time, the trial court would have narrowed down the area of where they think you believe you need to put in defense. If you don't know, so like you said, sometimes it's a way of like testing the water. By the time you now make a no case submission, and then no case submission is overruled, certainly the court would have pointed out where you failed. So in that aspect, I think these are one of the strategies. But I believe the substance you've discussed, I think virtually I have nothing to add until if my Lord is here. Thank you, Mr. Brown.
Thank you, Prof. Thank you once again. Thank you very much. So better.
But Mr. Chan, permit me to leave the room. Let me try, my Lord.
Okay. So better. Are you here?
Thank you very much. I'm still here. I mean, I would not fail to make a comment because you've done brilliantly well. I mean, those who are listening would probably think that you were delivering your own paper, but you took it straight off like a practitioner that you are. Thank you very much. Excellent presentation, and I'm sure you can see the comments from the people who listen. Very good. Thank you for standing in for my Lord. We're still hopeful that my Lord will join in, but I don't know how much we can wait to see whether he will come on. I think we can proceed to questions, really. Mabel, we haven't taken questions, right? Hello, Mabel.
Good afternoon, Mr. Chair, and thank you very much, Doc. It was quite an interesting one following through. We have questions here, so perhaps we can take them.
Mabel, what we'll do, we're still expecting that my Lord might jump in when he's done from court. But if we can keep taking questions when we finish, if he's in, then we will let him speak for whatever length of time that he can speak and then close. Otherwise, we do questions and move on and then adjourn till tomorrow. Yeah?
Very well, that works. Thank you once again, Doc. There are lots of appreciation from our participants here. I'll take the very first question from Olubode Savage. He says, the police usually commence criminal proceedings against some defendants with proof of evidence that clearly shows no case against all or some of the defendants. And this often leads to congestion of the court time. Why is the judiciary not doing anything to curb these improper activities by the police?
Thank you very much. I don't know whether I'm in a position to answer for the judiciary, but I would attempt to since I'm standing in for my Lord, so to speak, let me attempt to make light. We're making light of the situation to see if I can do justice to the question. I think it will not be too fair to assume that the inability of the court to take steps against some of these kind of complaints is rooted in the court's lack of power to do so. The court is open to all, prosecution and defendants alike. And the court must not be in a hurry to throw away the case of either party. So you see that in a situation where the police or even the prosecution, let us even leave the police now, though the question is related to the police prosecuting. In a situation where the prosecution, which is where the word I would like to use, whether police or lawyers from the ministry or any of the law enforcement agencies, come to court with inadequate documentation in their proof of evidence, and this is affecting the ability of the matter to proceed as quickly as it should. It is not always easy for the court to just throw them out because it would seem as if the court is unnecessarily being harsh. The burden is on the prosecution to prove the case against the defendant beyond reasonable doubt. That is a heavy burden on its own. So a lot of latitude is given to the prosecution because it has this burden to have sufficient time, reasonable time that is, to present their case, bring their documentation and all the rest, because nobody wants somebody who has committed a crime to go scot-free because of some technicalities, obviously. But I would not agree totally with the person who asked the question that when it is right to make an application to have such a case dismissed for want of diligent prosecution, that a court would not act. I think the courts have not failed to act. I can say that with all sense of responsibility. I may not be a judicial officer, but I have gone around the country practicing, because of practicing, and I know that once it is clear that a prosecuting counsel is not ready and the court has given it so much latitude to present this case and it has failed to present the case, an application made to the court to have the matter struck out would always be entertained by any judicial officer, and they've always exercised the power to strike out those matters until such a time that the person thinks is ready, can come back. Striking out at that level doesn't mean that they can't come back. So no harm is done to them. It's just that it saves the court the time to proceed forward with other matters in its docket rather than continuously putting a matter they're not ready to prosecute the dockets. So that will be my simple answer to that question.
Thank you very much. Ikechukwu Odemelam says, is there any danger if the defense counsel fails to make a no case submission and allow the prosecution to prove the case beyond reasonable doubt?
Well, there's no danger. The truth is this: making a no case submission is a matter of strategy by the defendant counsel. If you have a case where it is clear that to you, having assessed the position of the case adduced by the prosecution, and you are of the clear conclusion that it's going to fail, making a no case submission under such a circumstance is not the proper practice. A lot of lawyers do it. They just do it all the same so that at least they can say they exercise that right. But it's not proper practice when you know that from every indication it is clear that the case has been made out against your client. The proper thing is to prepare your client to enter his defense and provide whatever explanation he has against the allegations made against over the allegations made against him. But if you fail to do so in the circumstance where you feel that it will not succeed, and you've advised your client as to his chances and the lack of success of such an application, it's not wrong. It's proper practice. It should be commended, in fact, that you did not want to file an application that will waste the judicial time of the court. So you are ready to proceed the matter. I don't see it as a wrong thing. What is wrong is when it is clear that no case has been made out, and due to your inability to appreciate and master both the facts of the case and the law applicable to your case, you fail to take the opportunity that the law affords you to make a no case submission, to terminate the trial at that stage. If that would not be bordering on the lawyer not being diligent with his case, rather than inability to the procedure not being applicable to his case. That would be my answer.
Thank you. Jamila says, please can the presenter repeat his last point on application for no case submission and issue of stay of proceeding?
Okay, I think what I was trying to say there was that I was making reference to the conclusive remarks of my lord in his slide, where my lord did point out about the nature of prosecutorial policy and how that prosecutorial policy is affecting the way parties are not filing no case submission in the sort of every criminal trial that is going on virtually in the country. And my view was that I agree with my lord that we need to exercise prosecutorial powers. That's talking about prosecutors now. Exercise prosecutorial powers with all sense of responsibility. If a man is not supposed to be charged for the commission of a crime, there's no need doing so, simply because I think with this issue was raised, one of the presenters in this series about prosecuting just for the sake of maybe satisfying a system, or your boss wants this man to be dealt with, or the society demands that we act, and then you bring charges against somebody. And of course, the charges at the end of the day means nothing, and the man makes a no case submission. So I think my lord was pointing out the fact that this kind of poor prosecutorial practice or policy should be revisited, so that we can have a system where, until you are sure of succeeding to some extent in the prosecution of a defendant, there's no need to charges against him. So I try to draw my lord's conclusive remarks, a connection between my lord's conclusive remarks to the fact that, assuming the sections in AGJA and the different criminal justice law in different states did not make provision for parties not to stay in proceedings even when on appeal on, say, no case submission. Assuming there was no such provision, I could imagine, that's what I was trying to say, that I could imagine what would have happened where parties stay the trial and then go on appeal on the no case submission up to the Supreme Court and come back several years later to start the trial afresh again. Maybe by then some of the witnesses would have died and all that stuff. So it is that delay that would have caused and led them to put that provision that even when you are appealing, the trial can still be going on. If the outcome of the appeal affects the matter, so be it. You file an affidavit of facts and inform the court that the man has been discharged and acquitted by a higher court, and that's the end of the matter. So it is a development that I welcome in terms of the provisions of the Act that ensure that there's speedy dispensation of justice. That's what I was trying to say.
Thank you very much. Saidu Umar Gumi says, sir, where a no case submission was upheld, can the prosecution file a fresh case and charge the accused with a lesser offense?
Well, I think there's no specific answer to this particular question. It's an interesting question because there are provisions in the ACJA and of course the Constitution that deals with outrefort acquit, outrefort convict. A no case submission that is upheld is a final decision that's as good as an acquittal. So if the prosecution is unhappy with the decision, the proper thing to do is to file an appeal against it. But when the prosecution decides to take the same facts and file charges for a lesser offense, the question will not be, the way the defendant will deal with that situation will depend on what exactly is this lesser offense. That's why I said the answer to this question is not cut and dried. Because if the prosecution had the opportunity of, say, charging for several offenses, he is the prosecutor, he's the master of his case. The law gives him the power to decide what he wants to charge you with and what doesn't want to charge you with. But if the facts which would prove that lesser offense are the same facts with which he tried to prove the major one and failed, I would think that depending on the circumstance of the new sets of allegation, the defendant could come up with either an application to have that charge dismissed on grounds of outrefort acquit or outrefort convict, depending if he has been convicted. But since the question is particularly directed at this situation, I'll say outrefort acquit and urge the court to say that he cannot be tried under the same facts for the same kind of, for either an offense that is part of what he committed in committing the major one that for which the court has reviewed and discharged him. But there's also the argument that if he was not charged, if he can be convicted, if the prosecutor tried to prove the main offense, let's say in a situation where the trial gets to the very end and he gives evidence and the prosecutor is unable to prove the main offense, but was able to prove the lesser charge, we all know that the court has the power to convict for that lesser charge. In that instance, it simply means that the court, having heard the evidence in totality, can come to the conclusion at that stage that the man is not guilty of this particular one, but is guilty of this particular lesser offense, and of course convict on that. However, that situation is different from this situation, which is a new charge entirely on a lesser charge, but the same facts. So it will be up to the defendant at that stage, counsel at that stage, to apply to the court to see how lucky it can be with respect to whether, in that circumstance, the court can proceed with that trial under the circumstance where no case submission has been upheld, free him of the entirety of the facts which are now being used against him for a lesser offense.
Thank you. Thank you so much, Mr. Onyeke. That was succinctly presented. Now I'm quoting Kenneth Kale. Chijoke Okonkwo says, in view of the Supreme Court decisions that a notice of appeal is an originating process which cannot be regularized, will it still be advisable to file a notice of appeal before obtaining leave to appeal? I think this goes to the question of when you were talking about whether it was an interlocutory appeal or final appeal.
On the contrary, I think he was trying to see, what I think he's trying to ask is, if for any reason you decide to file an appeal without seeking leave where you need leave, and for any reason you get to the Court of Appeal and the issue of leave comes up, can you file an application at that stage, due to the fact that the notice of appeal itself has been held to be a originating process? Can you file an appeal to regularize it? I think we need to be clear on a point. The issue of leave is either because you file a notice of appeal on mixed law and facts when you're talking about no case submission situation, in which case you ought to seek leave from the lower court before filing and you're unable to do so because of constraint. If there's an opportunity presented by the rules of the Court of Appeal to allow you to seek leave on that particular process, I don't think exercising that right would not be available to you, because at the end of the day, the nature of regularization of a notice of appeal that would make it impossible for the court to regularize for you I don't think it's relates to the issue of leave. It could be a situation where the notice of appeal itself, let's say, for instance, in the way it was prepared. I give an example. Usually you prepare a notice of appeal by putting in the Court of Appeal, Lagos Judicial Division if you're in Lagos, and then, of course, the body of the appeal, the decision you're complaining about and all that stuff. Let's assume that for some reason you now went and put in the High Court. Obviously, that process is incompetent, because the notice of appeal is a process meant for the Court of Appeal, filed at the appellate registry of the lower court, and will be transmitted by the appellate registry to the registry of the Court of Appeal for their use. So when you have titled it wrongly, I'm giving such an instance, you cannot be asking the court to regularize that kind of position, because obviously, by his very, very, I'm looking for the right word to use now. By the nature of the mistakes you have made, is not one that can be regularized in that manner. So you will either withdraw that appeal totally, and then use the treaty prayers if you're out of time to file a fresh appeal and abandon that one, so that you know that you are on proper footing now. Instead of trying to repair what is essentially bad. Like I said, if something is bad, it's incredibly bad, and you cannot put something on nothing. So I don't think that is the kind of category of matters to be regularized that this instance I'm talking about falls into. This one I'm talking about, you can seek leave of the lower court, you can seek leave of the Court of Appeal. I hope that when my Lord comes and this question is repeated, or maybe we'll ask him directly so that we can get the full measure of his response and his experience in handling these matters. But I don't think that when there's a provision to regularize and seek leave at the appellate court, it's like the Supreme Court. I mean, we all go there, and recently I was there to regularize appeals that are normally the appeal from the Court of Appeal to the Supreme Court for criminal matters is not 90 days. It is 30 days, Section 27 of the Supreme Court Act. Now, people make the mistake of thinking that because all final decisions is 90 days, that when you have a criminal matter that has ended at the Court of Appeal and you want to file to the Supreme Court, you have 90 days. You don't have 90 days, you have 30 days. So if you now file outside the 30 days period, obviously you know you are going to need to regularize that appeal. So regularizing it at the Supreme Court, you do the necessary processes that the Supreme Court expects you to do, so that your appeal before it will be proper and competent. At that kind of procedure is allowed at the Supreme Court. You cannot say such a process that will regularize that appeal is not right. That's the point I'm trying to make. Yes.
Thank you very much.
Docs.
Yes.
Docs.
Yes.
Hello, Docs.
I can hear you.
Yeah, I just wanted to make a point. Very unfortunate incident. I just spoke to my Lord. It appears that he did not receive the email that was sent to him earlier. So we're trying to send the link to him now. He had actually been waiting since 12, and we thought he was sitting. So that's really sad and unfortunate. I'm trying to get Wole to send him the link right away, so that he can come on, even if it's do a summary of his paper. So I'll just ask you to please hold forth, keep the session going until he joins up. Thank you. We'll solve this at the back end.
Okay, thank you. All right.
Thank you. Judge Queen Ubo Umana says, what if the proceedings is in a general court martial, which is quite distinct from our daily court proceedings? Most times the procedure or system in this in the GCM is quite strict and almost prejudicial to the accused person.
Well, I have done one or two court martials. That was some years past, sometime in the 90s. And I'll tell you that, anything with the military and all those people, they are usually not as liberal as we are. But a court martial decision is appealable to the Court of Appeal and then to the Supreme Court. So what I would say is to anybody who is representing a defendant at the court martial is that be patient with them. Listen to all that is happening. Take note of all the procedures that are against fair hearing that takes place there or took place there, and then make it a point of appeal. First of all, once the right to fair hearing is breached in any way, draw the attention of the court, the panel to it. Once they get them to rule on it, so that it will form part of their proceedings. Whatever decision they take is okay. At the end of the day, if the man is convicted or the defendant is convicted, when he's filing his appeal, he can raise those issues as to the way the court martial was conducted and how he was denied fair hearing. The Court of Appeal is not a military setup, unlike the court martial, where you have a military setup. Maybe the person who is the head of the court martial, or there's a judge advocate there who's supposed to explain a position of the law to some of the members of the panel. And if they refuse to heed this counsel, maybe because it's a junior officer, there's very little you can do, because the way court martials are constituted, if you are in the rank that is a general rank, it is people of your peers that can try you. You cannot have, worst case scenario, a colonel would be one of the people, but it must be an officer that is above you or within your rank that will try you. You cannot have a junior officer trying a senior officer. So if the judge advocate in that instance is, say, a junior rank officer, his job in the course of the court martial is to advise the court martial panel as to the position of the law on some issues that are raised there, if they are not lawyers. And if at the end of the day they do not listen to him, the military is still subject to the Constitution of Nigeria. They swore, of course, everybody, they are the ones who swore to uphold the Constitution. So the Constitution still provides that everybody is entitled to a fair trial. So you can bring that to the Court of Appeal and deal with that issue instead of making it an issue that will become a problem at the court martial.
Okay, thank you. There's another question here. Is it not possible to appeal on the no case submission along with the appeal on the entire case?
I think the procedure as the Court of Appeal, either the rules before this time or even the same rules, it allows for a situation where the Court of Appeal can take your notice of appeal, and once the trial is still ongoing and it's clear that the trial will be concluded soon, keep your appeal in abeyance and ask you to finish the main trial and bring those both together. If you don't succeed here, that's if you are convicted, file an appeal and apply for the two to be consolidated. There's a procedure in the Court of Appeal rules for that. So if you as counsel decide to file an appeal just so that you are within time to file the appeal, and then you decide to compile records, do all the necessary you need to do, but take no further step to bring the appeal, to make it ripe for hearing, and then decide to await the outcome of the decision in the main trial. And then if it's against you, decide to file an appeal and then draw the court's attention, it's okay. But it's not always so strategically nice to adopt that strategy, unless, of course, the court insists on. In one particular case we did, the Court of Appeal insisted that since the trial was still ongoing, we should go and complete that one. I think there was a lot of congestion then, and the Court of Appeal just said, look, there's a trial going on, go back and complete it. But recently, there have been the attitude has always been to hear all appeals, whether it's no case submission or the main one, we hear it on its merit and rule on it, so that if you want to appeal to the Supreme Court, go ahead and do that. I would rather that you don't adopt that attitude of keeping it or waiting, because the issue at the end of the day, when the judgment is delivered against the defendant and is found guilty, the nature of appeal is different. The grounds of appeal becomes different. And those grounds of appeal cannot be the same kind of grounds of appeal in no-case submission. In no-case submission, you're dealing with one side of the case. In the other one, you're dealing with the two cases, the entirety of the case itself. So the two grounds are different. It's always better to pursue the no-case submission, because if the no-case submission succeeds at the appellate court, it automatically puts an end to the trial going on, or even if there has been a conviction, it ends that conviction because it was first in time and it's assumed as if nothing happened after that no-case submission decision that has now been upheld by the appellate court. So why would you want to deny yourself of the opportunity of having that kind of advantage? That's just my own thinking in that direction.
Thank you. This is quite a lengthy one, but I'll take it. It says most times you will see that the defendant in court may be more than one person. And when questions are being asked during cross-examination, the other defendants are not meant to be in court. All defendants will be there and will listen to the question being asked to their co-accused. Now, my question is, where a counsel for a particular defendant, for example, let's say counsel for the first defendant, tries to establish a no-case submission, and the other defendant who has a case to answer, wouldn't the presence of the other defendant affect the prosecution's case, knowing very well that if the counsel for the first defendant is successful in his no-case submission, the remaining defendant will align to that, when it is obvious that maybe the second and the third defendant has a case to answer?
I don't think it operates that way. When defendants are charged either jointly or severally and they decide to make no case submission because they are represented by different counsel, each defendant will present his argument as to how the case adduced by prosecution did not establish a prima facie case against him or her, as the case may be. At that stage, it is the prosecution's duty to establish or to argue that a case was made out against the defendant. Not, Prof, can you mute yourself? No. At that stage, it is the duty of the defendant. I don't know that I can do this interference. Prof. Thank you. No, at that stage, it is up to the, let me use this example. If the first defendant counsel makes a no-case submission and he succeeds, it doesn't mean that the other people in aligning will succeed. No, because the level of involvement and participation in the allegations may be different. But if the entirety of the case of the prosecution is built along the same piece of evidence and involvement, obviously, when one succeeds, the other may of course, the others may succeed. So I do not think that in a case where, because the no case submission succeeded with one defendant, it means that it succeed with the other defendant, it doesn't apply that way. It doesn't apply. Whether they are in court or not doesn't matter.
Docs.
Yes.
Docs, I think I can see.
My Lord has joined us.
I can see my Lord Justice Shoaib is here. My Lord, welcome. We apologize once again for the unfortunate incident, and we're happy to welcome you. Thank you very much for your kindness and for joining us nevertheless.
Yes, it's been a pleasure. They said better late than never. Are you with me?
Thank you, sir. Yes, we are with you, sir. Thank you very much.
Are you ready for me now?
We are very much ready for you, sir.
Thank you very much. I will first of all thank you for inviting me to say a word or two on the topic which is also dear to me. I also wish to apologize ahead for the fact that you may not probably get what you are expecting. But nonetheless, I will just try my little best to give my views on the topic, the appeals against no case submission application. By way of introduction, I look at the provision of the Constitution, section 36, which is the presumption of innocence, to say that this criminal system try as much as possible to ensure that that is a very conventional way of arriving at justice. Therefore, that's why we have a presumption of innocence, as well as the provision that also said that a person tried for a criminal offense shall not be compelled to give evidence at the trial. Well, be that as it may, the provision of our courts, are you talking of criminal procedure code applicable to Northern Nigeria, criminal procedure code, and what have you, all contains provision dealing with no case submission. So it's not a new thing. More recently, as you all know, by the provision of section 302 and 303 of Administration of Criminal Justice Act, the provision of no case submission is also enacted and entrenched into the Administration of Criminal Justice Act. And the guidelines, the requirement as it's contained under the courts, as well as the Administration of Criminal Justice Act, are virtually the same, except an attempt has also been made, instead of the defendant or accused person, as you may choose to call him, decides after the close of the case of the prosecution to raise a no case submission, the criteria or the guidelines are the same. That essential element has not been proved, or there is no evidence linking to the accused with the commission of the offense, or the evidence led by the prosecution was so discredited that no reasonable court or tribunal will convict on such evidence. The innovation provided is under subsection 3, 303 subsection 3D, to the effect that the court may, on its own volition, after the close of the prosecution case, may decide to say that, oh, no case no prima facie has been made out, and for the defendant to be called upon to defend. That is virtually another area which is very novel, that even the court on its own motion can, based on the evidence adduced by the prosecution, can say, oh, no case submission has been made. So all what I'm trying to say is that the defendant in a criminal trial has the right to raise no case submission at the end of the evidence adduced by the prosecution. The essence of the application is that the pieces of evidence for the prosecution did not establish essential ingredients, or that through the fair cross-examination, the evidence has been rendered useless, and that the court, after perusal of the pieces of evidence so far preferred by the prosecution witnesses, then decide, having taken into consideration all the aforesaid factors, that the three factors I mentioned, that no case has been made against the defendant, which will require him to offer some explanation. It is also important to emphasize here that the trial court does not evaluate or ascribe any probative value to the evidence presented by the prosecution, and that explains the requirement that merely the establishment of prima facie, which was severally defined as the slightest evidence legally admissible against the defendant. No case submission is that there is no evidence, no matter how slightest, linking the accused with the offense charged. Now, moving forward to the main theme of my discourse, that is the appeal against the ruling of no case submission, where if it appears to the trial court that a case has been sufficiently made out against the defendant, the no case submission will certainly fail. The degree of sufficiency required is a prima facie, as stated earlier, as there cannot be any standard other than prima facie evidence adduced by the prosecution, even if believed by the court, cannot convict the defendant. The no case submission must be upheld by the trial court. In a no case submission discharge, it is also pertinent to note, a discharge on a no case submission amount to acquittal or a dismissal of the complaint. There are several authorities to support the position. Now, the 100 million naira question is the time to appeal against the ruling of on no case submission. The 1999 Constitution, by virtue of Section 241 and 242 sub 1, creates two rights of appeal from the decision of the High Court, be it Federal High Court or High Court of the State. These rights are the right of appeal as of right and the right of appeal with leave. We all know the two rights. Now, furthermore, the provision of Section 14 of Court of Appeal Act provides that leave must first be sought and obtained before filing an appeal against interlocutory decisions of the trial court, particularly where the grounds are not ground of law alone. The question then is, an appeal against a no case submission, a species of interlocutory appeals requiring either leave of the trial court or the Court of Appeal. I look at a decision of this Court of Appeal, that is of Gordon against Federal Republic of Nigeria, decided in 2017. I provided a citation in the cliff that this court has said that appellant having not limited himself to grounds of law alone and went further into the body of fact, was subsequently caught by the constitutional requirement of leave prior to the filing of the notice of appeal. As I
Sorry, my lord, I think they have a problem with the volume at your end.
Can't you hear me? The volume.
I'm not hearing you very well myself.
Okay.
If everybody having this problem,
we can hear you very well. We can hear you very well.
Oh, you can? Okay, fine. If you can, it's fine. The Lord continue.
So Bena, is your handset? I hope you are not using China like me.
My lord, I apologize.
I also took another, that was the Court of Appeal decision. Now I look at another decision of the Supreme Court. That is the case of Dankofa against the Republic of Nigeria. Dankofa is a current professor also of law in the Faculty of Law at Ahmadu Bello University. My younger brother too. He was tried, and at the end of the prosecution case, he raised a no case submission. And the Supreme Court was emphatic that an appeal on a no case submission requires leave to appeal because the ruling of the trial court on a no case submission necessarily, I repeat, necessarily involves a critical examination of the element of the count or counts for which the appellant is charged to ascertain if prima facie case has been made out to require his defense to the charge or charges. That is the position of the Supreme Court. So if we are to follow this decision, we may say, irrespective of whatever the decision or ruling on a no case submission, because of the element of the fact, because it's the facts that will necessarily show whether the offense was committed, whether that is evidence to link the accused and with the offense, that leave is necessarily required. The reason, in my own view, of the decision of the Supreme Court is that the four grounds of appeal were grounds of mixed law and fact. The requirement of leave to appeal was held to be procedural requirement of constitutional significance, wherein the court might overlook in deserving situation, in the cause clause for the purpose of doing substantial justice. That is what the Supreme Court said in Dankopa. However, the constitutional requirement of leave to appeal, though procedural, could not be waived, as doing otherwise would render the decision unconstitutional. Same one and the same thing at the same time. I look at other scenarios where, not necessarily on no case submission, a situation where there is wrongful admission of evidence, where you can match the interlocutory appeal with the main appeal, in which case you do not require leave of the court. But going forward, the implication of the Apex Court decision in Dankofa, which outrightly said that leave is pertinent, is that the ruling on no case submission, in my humble view, may and may not necessarily require leave to appeal, depending on the nature of the order handed down by the trial court. I hope I'm understood. It may and it may not. As stated earlier, the decision in Dankopa was based on the challenges of the correctness of the trial court's decision on the no case submission made by the appellant, and hence a complaint on the application of law to the fact by the trial court, in which the 4 grounds of appeal were issues of mixed law and fact. In such situation, there was no way the Court of Appeal could determine the appeal was out, considering the facts in the evidence adduced by the prosecution. Lest I forget, the application for a no case submission in that case was overruled by the trial court, being an interlocutory decision, which group rooms for the parties to go back to the same court to ask it to decide on the same matter. You see, the situation I'm trying to point out here is where in a situation the application for no case submission was overruled, the decision, in my view, become an interlocutory decision, because you are still going back to that court. The right of the parties was not finally determined. Therefore, the decision is interlocutory. But the situation will certainly be different, where a decision on a no case submission finally disposes all the rights of the parties in the case and give no room to go back to the same court to ask it to decide on the same matter. Therefore, where the trial court upholds the no case submission, it finally disposes the rights of the parties and same become a final decision. And since it is a final decision, by virtue of section 241, sub 1A of the Constitution, leave is not required in final decision of either the Federal High Court or the High Court sitting at first instance. This is irrespective of a plethora of the decision that says if the decision is final, irrespective of the nature of the grounds of appeal, the right of appeal is as of right. So if a no case submission, the right of the parties is finally determined, the decision is final, and irrespective of the grounds of appeal, the leave of the trial court or the court of appeal is certainly not required. This is my view, my personal view. Probably if to Ben and others argue the matter and bring maybe a superior decision, probably I will lean towards that. But as of now, my view is if the decision is final, then irrespective of the grounds of appeal, leave is not required because it is an appeal as of right. Now, perhaps I may need to state here that it is a constitutional requirement that where grounds of appeal raises question of mixed law and fact, leave of either the Court of Appeal or the Supreme Court is required by virtue of section 233, sub 3 of the 1999 Constitution. What am I saying? At the appeal from the High Court to the Federal High Court, to the Court of Appeal, if it is a final decision, no leave is required in any decision, inclusive of decision on no case submission. But the provision of section 233 sub 3 is not a replication of Section 241 sub 1A. While there is no requirement of leave against final decision of the trial court on a no-case submission to the Court of Appeal, it is mandatory to seek leave to appeal to the Supreme Court when the grounds of appeal raises mixed law and facts. The Supreme Court is appeal on a no-case submission to the Supreme Court necessarily involve question of mixed law and fact, and that it is a final, irrespective of final or interlocutory, the leave of court must be sought and obtained. Now, as we all know, talking about the remedy for not seeking leave, when leave is mandatorily required, the law is very certain that a court is only competent to adjudicate in a matter when, among other conditions, the subject matter of the suit is competently before the court and when the action is initiated by due process. So it follows, therefore, that failure of an appellant to seek and obtain the mandatory or statutorily or constitutionally required leave to appeal render the notice of appeal. I cited the case of Ikureku to the effect that where an appeal requires leave to be obtained and the leave was not obtained, such appeal is incompetent and will be struck out. This is so because a court of law has no jurisdiction to hear an incompetent appeal. And where an appeal is adjudged incompetent ab initio, the appellate court has no jurisdiction to entertain and determine the appeal. Same is to be struck out. Now, it was also, I was also asked as to the nature and the grounds of appeal against the decision of no-case submission. Where, for example, the trial court erroneously comes to the conclusion that there is no evidence to prove essential ingredient of the offense and proceed to discharge the defendant, or the court erroneously holds that the evidence adduced by the prosecution has been thoroughly discredited as a result of cross-examination or is manifestly unreliable, that no reasonable tribunal could safely convict on it, the prosecution has an undoubted right to appeal against such a ruling. And by the same token, the defendant is not entitled also from such right to appeal where he is dissatisfied with the ruling of the trial. Now, the nature of the grounds of appeal may vary depending on the complaint against such a ruling, but very often they are premised on the misapplication of law to the fact in relation to establishing prima facie case against the defendant, and that the evidence so far adduced is discredited and the no reasonable court or tribunal will convict on it. Usually, the grounds are usually of mixed law and fact. In conclusion, I said the application for no-case submission is increasingly become a norm in virtually all criminal trials before Nigerian courts. In fact, it's been used as a tool with due respect by lawyers very often, whether to test the waters and also to impress their clients that whatever evidence is there, they have to, as a norm, test to see whether air occupies space by applying for a no-case submission. And another reason, apart from the ploy by defense counsel to delay and delay, even when there is evidence linking the accused person, even where the evidence adduced was not discredited. The defense usually tests the waters. Another problem is also associated with the prosecution policy. In my view, all this account for delays and in some instances, even abuse of court processes. What do I mean by prosecution policies. The prosecution policy over the years and up to today is that prima facie, as against what I may describe as a reasonable prospect of conviction. In some crime, the policy is that the prosecution, for a prosecution to file a charge, he must ensure that there is a prospect of conviction. But here is that prima facie, that no matter how small, how evidence is that link the accused with the offense, we go to court, let the court determine. I will tell you, when I was growing up as a small prosecutor in the mid 80s, that has been the training we received, that, oh, go to court, let the court decide. I think that is not a good policy. As a prosecuting agency, you must be sure that there is prospect of conviction. Otherwise, you don't need to waste the money, the taxpayers' money, to go to court. So I advocate and suggest that there must be a freedom shift towards the prosecution policy, that emphasis must be given on the prospect of conviction as against the prima facie case. Gentlemen, I think I'm able to say something, whether it meets your expectation or not. At least I've made up my mind that this is my little contribution. Thank you very much. I'm ready for whatever question you may have to ask. Thank you so much. I hope I'm okay. Yes, Dr. Nasuru, I can see you now. Oh, Professor Nasuru.
Mr. Chairman, Sabina.
I'm expecting your question.
Yes, the secretary will handle the other questions, which have already been, I've seen them lined up. Mr. Chairman, can you hear me? Well, I think, Mr. Chairman, just, well, Milord, I must commend Milord despite the problem. I'm very sorry for the mix-up that they were unable to send you the link, because Milord, you are in court, I was in a meeting. All the same, I just flipped through and I saw your message. We're very sorry, Milord. And yes, Docs.
Yeah, I can hear you.
My line is over.
Okay. My Lord, let me first of all thank you very much for the presentation. It was very sharp, straight to the point. We were all waiting for my Lord to answer a particular question, and my Lord has definitely answered it, which is the issue of when to appeal a no-case submission. And I particularly was waiting for it because I had the privilege, my Lord, of standing in for you while we were waiting for you. I know I couldn't feel your big shoes, my Lord, so I just attempted to put in my leg a little bit into the shoes. And that was one area that I felt that we needed to hear my Lord's position on. And I thank my Lord for the way my Lord broke it down. And we are all now well tutored as to the difference in when it is 14 days and when it is 90 days based on a final decision or interlocutory decision. Once again, my Lord, thank you very much for coming onto the platform. The entirety of the Nigerian Bar Association greets you and thanks you for the sacrifice. We know that you're a very busy man, and creating time to come here is something that we appreciate very, very seriously. There are a few questions. I also was standing in for you, taking some of the questions, but I think some other questions have come in the course of your presentation. One of the questions, my Lord, yes.
My Lord has sent his CV. I think very well, because I am on the transit now. I will send it to you just in case, before you close up, to read my CV, so that at least as the I'm going to send it to you in the interim so you can be able to read it for the other colleagues to hear.
No
Thank
problem.
you. I'm sending it to you. I'm sending it to you.
Okay, no problem.
All right.
All right.
Thank you. Sorry for the explanation.
No, it's okay. My Lord, one of the questions that came up in the course of your presentation is, well, this one is not related to your presentation, but since you are here, everybody wants to use the opportunity of tapping into my Lord's wealth of wisdom. Does a nominal complainant who is called to the bar need the fiat of the Attorney General to prosecute his case by himself in a magistrate court? My Lord, did you hear me?
I can hear you.
Yes, it's not related to your topic, but
no, I can understand. Well, fortunately, I was a prosecutor. I prosecuted for almost 17 years.
Ah, that's good. That's good.
You see, the issue of prosecution is entirely the discretion given to, or the powers are essentially vested in the office of the Attorney General, pursuant to the provision of Section 174 and 211 of the 1999 Constitution. Now, for a private individual, there are plethora of decisions, you know, Pawemi Akilu and what have you, on the circumstances under which a private individual can initiate criminal proceedings. My take is the powers of the Attorney General is to initiate, take over and discontinue. You understand? Incidentally, sometimes last 2 weeks, I was also privileged to give a talk on a criminal law provisions, suppression of piracy on the sea. They provided the power of the agency to prosecute, but subject to the consent of the Attorney General. There are provisions also on other statutory bodies giving them power to prosecute. But whatever power they have, it resides with the Attorney General, whether at the federal or state level. But for a private individual to initiate criminal proceedings, I think it is necessary to seek the consent of the Attorney General, on whose the power to prosecute to reside exclusively. I hope I attempt to answer the question. So you want to prosecute, whether at any level, that power is on the Attorney General. You can understand. In fact, there is this decision. I can remember the Supreme Court decision, Osahon against Federal Republic of Nigeria, whether the police have the prosecutory power, but that power on the police, the custom, and NDL, and what have you, is entrenched into the statutes. Why the statutes do not give the power? I think you have to ask for permission. You want to enter someone's house, you must ask him for permission to enter.
Thank you very much.
Provided me with the link to be with you. Without the link, I was unable to talk to you.
Thank you very much, my Lord.
Yes.
There are other questions here, but most of them were questions that we took before you came. And there were questions that we took before you came while we were waiting for you to log in. I don't think that some of them have been taken. Well, this one is interesting. In the course of holding forth for my Lord, I did mention that the appeal from the Court of Appeal to the Supreme Court of Criminal Matter is not 90 days, but 30 days, under Section 27 of the Supreme Court Act. And somebody has raised a question on it, that is the provision that appeal on the criminal case should be filed within 30 days at the Supreme Court, as you stated, not in conflict with the Constitution that gives a period of 90 days within which to appeal a final decision. My Lord, what's your take on that?
Well, interestingly, there is a statute which is being interpreted even recently that limited the power. They call I cannot probably say it precisely, but it's a prosecution, judicial officers' prosecutory right to appeal is a 1968 legislation that limited the power of the prosecution to appeal on murder cases, to limited it from limited, I think, to 7 days.
7 days, 7 days, man. 7 days.
7 days. Yes. And the Supreme Court legitimized that provision. They said it's not in conflict. But that provision was held to be integral part of the Constitution, courtesy of the provision of Section 315 as an existing law.
Yes.
So the power may and may not be in conflict with the provision of the Constitution, but that one specifically that limited the power. And the reasoning was that they went to
Yes, yes.
Oh yeah, Juan.
Don't hook. You don't hook from my Lord's side. My Lord, we can no longer hear you. I think your network. My Lord, your network is done. I think we can't hear you anymore. Nasir, are you still online? Can you hear
No, I
me?
cannot hear him. I cannot hear him also. This line has frozen.
I think my Lord's line is
Maybe it's network.
his network, yes. I would have used this opportunity now to do a bit of introduction of my Lord for those of us who are not aware. My Lord, I will start with his resume because it's very, very big. My Lord Justice Muhammad Lawal Shoaibu is from Jigawa State and happily married. My Lord started his legal practice after obtaining the relevant educational qualification from the primary, secondary, and university level. He was at University of Sokoto, where he obtained his Bachelor of Laws and was called to the bar in 1984-1985. My Lord proceeded to the Institute of Administrators, where he obtained a certificate in legislative drafting. Subsequently, my Lord also attended the Law Enforcement Academy at Roswell in the United States of America, where he obtained a certificate in law enforcement model. His professional careers, which has spanned a long period, was that of, my Lord was at the Palm Produce Board in Calabar, Cross River State during his NYSC. He was at Ministry of Justice, Kano State as a state counsel in 1986 to 1990. Between 1990 and 1994, my Lord was the Minister of Justice, Duse Jigawa, as Director of Public Prosecution. My Lord also, between 1994 and 2002, was the Ministry of Justice, Duse, where he was the Solicitor General and Permanent Secretary of the Ministry of Justice. My Lord is back now. My Lord, I'm telling our participants, I'm reading out your CV, very rich CV to our participants at this time, because we ought to have done that before, but because of time, we just wanted my Lord to get into the mix of things. Between 2014 to date, my Lord has been a justice of the Court of Appeal after a stint at the Federal High Court where he was a judge and handled a lot of EFCC cases between 2003 to 2014. My Lord has attended several professional courses, a workshop for top management civil servants at Nigerian Institute of Social and Economic Research in Ibadan. He has trained the trainers workshop at Center for African Law and Development, Abuja, induction courses for newly appointed judges and cadets by National Judicial Institute in Abuja, training of computer appreciation and the internet in Lagos in 2003. 1 second, please. My Lord, my Lord, I can abridge it, my Lord, but we are very happy to have my Lord here. We're not going to abridge, my Lord. My Lord was also at the trainer workshop by the organized by the Federal Ministry of Justice with support of the UK Foreign and Commonwealth Office in Abuja, the Economic and Financial Training for EFCC designated judges at Center for Studies of Economic Crimes at the University of Johannesburg, South Africa, sub-regional roundtable on non-conviction-based asset forfeiture and asset management by UNIDOC at Abuja, International Symposium on Economic Crime at Jesus College, Cambridge, UK, roundtable consultation of the interagency group on international and national strategy to combat corruption in Abuja, and capacity development training organized on corruption and good governance in Accra, Ghana. My Lord, has been involved in series of seminars as a speaker, where he has been the resource person in matters concerning sentencing, extradition, review of federal high court rules, asset forfeiture, quarterly reports on performance and evaluation of judicial officers, as well as chairman working group on the drafting of the bill on stolen assets and recovery of management proceeds of crime set up by the Attorney General of the Federation in Abuja. Suffice it to say that my Lord is one of the justices of the Court of Appeal in Nigeria. My Lord is a member of several professional bodies, including the Nigerian Bar Association, the National Association for the Reform of Criminal Justice Administration, and member is Overseas International. My Lord hobbies includes reading and football. My Lord has also delivered several judgments on economic crimes and intellectual property, admiralty, and many areas of law. My Lord has been a recipient of several awards, both national and international, as well as letters of appreciation on my Lord's multifaceted approach to a lot of issues in terms of training and resource development. My Lord Justice Shoaibu is our guest for today, who has honored us with his presence despite the mistake we made in not sending him the link to join this thing, this forum. We, once again, my Lord, appreciate your presence and your very well-researched position and enlightening position on the issue of law. My Lord would not know what you have done for us today. Some of us who have had challenges with certain areas when it comes to appeal on criminal laws, we were all ready to listen to you today so that we don't make the mistakes that has bedeviled some of us in respect to the appeals filed at the Court of Appeal. So once again, I express the appreciation of every participant in this particular seminar today, as well as those of us, the panelists and members of the faculty, to you for your presence. Thank you very much, my Lord.
Thank you very much for the rare opportunity. I thank you for having me and for the robots discussion. I had occasion to join you on other series apart from today. So I've been following you, and you are doing a great work, and keep it up.
Thank you very much, my Lord. Thank you very much.
God bless. Thank you so much. I appreciate it. Thank you. Bye-bye.
Yes. Thank you. Nasiru, any closing remarks?
I will use this opportunity to thank my Lord also. I know, and we're very sorry, my Lord, for the problem of not sending the link early enough. And my Lord has been asking me about the link since yesterday. And I told my Lord, that it is going to be automatically generated. Unfortunately, I didn't know that my Lord's email was not listed. We're very sorry, my Lord. This is the first time we got this problem, and we sincerely apologize. And we thank my Lord. And my Lord, I will say for this short presentation, my Lord, there are a lot of questions which were bugging my mind, which I have got to answer now. I thank my Lord.
Yes.
Thank you, bro. Thank you very much. God bless all of you.
Thank you very much, sir.
Thank you. I'm honored. I appreciate it. Bye-bye.
Thank you very much.
Bye-bye.
Sir. Thank you, sir.
Thank you. Bye-bye.
So, ladies and gentlemen, we've come to the end of today's proceedings. It was extended by a few minutes due to circumstances that we were faced with today. I want to thank each and every one of you. We can resume again tomorrow. Tomorrow being Friday, it will be by 3 p.m. to afford participants enough time to go to the bus and be back. So 3 p.m. tomorrow. And let me inform us all that tomorrow we have the Honorable Justice Rose Vival of the Supreme Court, retired, will be presenting a paper to us tomorrow. So we look forward to having us come back here again tomorrow to be an enriching session. We hope that we'll see each and every one of you and more of you here tomorrow from 3 p.m. to about 5 p.m. when Justice Rose Vival will be handling tomorrow's presentation. I hand over to Mabel to bring this proceedings to a close.
Thank you very much, Mr. Onyeke. Prof, we thank you so much. And our participants, we thank you all for attending. And without much ado, from the ICLE, we wish you a very good evening and we look forward to seeing you again tomorrow. Thank you.
Bye.
Maybe, bye-bye.